The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. I'd like to especially welcome the students this morning from Mount Vernon, Grinnell, and Collins Maxwell. Thank you so much for being a part of our proceeding, and I would like to welcome as well all the students across the state who are participating in these proceedings because we are today celebrating Constitution Day. It was the day our Constitution was written at the convention on Monday, September 17th of 1787, and we've selected today to celebrate that occasion, as well as the occasion of the signing of our own state constitution 160 years ago in 1857. The presence of both those documents in our life is truly a reason to celebrate, and it's nice to have this day to do it. Our Constitution has given so much meaning to us as a country and as a state and as individuals as to who we are and who we can become. It guides us forward on our common values of equality, of freedoms, and of fairness. It's important today for us to celebrate, and it helps illustrate who we are. The case this morning is a part of this because it illustrates the role of our Constitution in our life. So we are pleased that everyone is interested in participating. We have 4 cases this morning that will be submitted. The first case is State of Iowa versus City of Cedar Rapids versus Marla Leaf. The second case is Myron Behm and others versus City of Cedar Rapids. Those 2 cases are combined for oral argument this morning. The third case is State of Iowa versus Iowa District Court for Jones County. And the final case is Linda Lynn and Mark Shuck versus Pat Montgomery and others. Now that last case is now submitted to the court without an oral argument, and will proceed to hear the arguments in the combined cases of City of Cedar Rapids versus Leaf and Behm versus City of Cedar Rapids. Mr. Larew.
Thank you, Your Honor. May it please the court, counsel. This court described the view of today's growing majority of Iowans about the use of automated traffic control ordinances when, back in 2008, in the case City of Davenport versus Seymour, it observed, opponents may view ATE ordinances as unduly intrusive, unfair, and simply amounting to sophisticated speed traps designed to raise funds for cash-strapped municipalities by ensnaring unsuspected car owners in a municipal bureaucracy under the circumstances where most busy people find it preferable to shut up and pay rather than to scream and to fight. Now, nearly a decade later, in 2 separate appeals arising under 2 separate legal proceedings, defendant appellant Marla Leaf, on her own behalf, and a group of class action plaintiffs refuse to be stilled. They arise as advocates against what they believe to be unlawful and unconstitutional practices implemented by the City of Cedar Rapids and its joint venture, for-profit, contingency fee partner, Gatso USA, in the exercise of the powers in the administration of the city's ATE ordinance. Before setting forth the legal argument, I wanted to lay a few of the facts out in terms of a visualization of what these cases both involve. I trust that the justices have been handed a page from the appendix just to highlight it. Behind me is a copy of the segment of road through Cedar Rapids, I-380, which transverses in a northerly-southerly direction through the city, going what is called sometimes an S-curve. On that segment of highway, one of the only places, and in fact in Iowa, are the only places where fixed speed ATE cameras are placed on interstate highway segments. In this instance, there are 4 such placements at the northerly part of the S-curve and at the southerly part. The pink dots represent locations where plaintiffs in the class action suit received citations. The green dot is where Marla Leaf received hers on a separate occasion. The arguments that we are making about the implementation of this ordinance at that place stands on its own ground, but is not inconsistent with findings made by the Iowa Department of Transportation in a letter to the city March 17th, 2015, directing them to remove completely 2 sets of these cameras, the northbound J Avenue, which is on the northerly side, top part of this chart, and also the southerly at First Avenue, because neither of them, the Department of Transportation said, had a sufficient link to any claim for public safety. They had reviewed crash data and found that if you compared before and after the placement of these cameras, there was no decrease in the crash data numbers. And what had gone up remarkably were the number of citations issued by the city and the amount of revenues collected by it and Gatso in the implementation of the ordinance. The other 2 locations the DOT ordered must be removed, and if put back in place, must be done so in a way that conformed with Iowa law. The law being that you must have at least 1,000 feet between the placement of a change of speed sign and the location of a speed camera. These findings are important independently of our arguments, but supportive of them, because we believe that there is no legal cause, no purpose that is colorable that could support the placement of these cameras, and as such would be unconstitutional. We bring to the court a series of arguments combined in each of these cases. Marla Leaf went through the entire challenge process, ending up first with an administrative hearing, which I'll talk about in a moment. Second, went to the district court on an appeal to the magistrate judge. Third, appealed that to the district court judge sitting in its appellate capacity, then to the Court of Appeals by direction of this court, and now it's before this body.
Before you get there, I'd just like to ask one question that relates to your presentation so far, and that is, supposing there's a posted speed limit of 65 miles an hour on a straightaway, and a study shows that you can go 75 with equal safety. DOT has done an elaborate study, like in my hypothetical. Could the 65 mile an hour speed limit be constitutionally enforced, even though there's a showing that it didn't advance safety in this particular case?
Yes, I think the appropriate jurisdictional authority has the discretion to use its judgment as to how fast vehicles should travel in a given segment of road. Here, there doesn't seem to be much question, at least on behalf of the clients I represent, who has that jurisdictional authority. There's a case that this body will hear, or the Court of Appeals, where the 3 cities, Muscatine, Davenport, Cedar Rapids, challenged the DOT's authority to issue this order.
It's fair to say that if, instead of having the automated traffic cameras where the various dots are, if a live officer had been there with a radar gun or whatever, and pulled the clients over, that would not have a constitutional infirmity, I take it.
Well, it would depend how the matter was prosecuted. If that,
As a speeding matter.
well, there's a speeding matter and that followed the Iowa statute, which is applicable to the prosecution of municipal infractions. Yes, that's possible.
And I understand you've got statutory and administrative arguments that you're about to get to, and I will let you get there really quickly, but I'm probing the constitutional dimensions of the case and just trying to understand if it would not have been a violation of substantive due process and et cetera to have a live officer there. Why is it a violation, a constitutional violation, to have a camera there?
Well, it has to do more with the form of one, prosecution, and 2, what resources a person may have to defend oneself against those. Yeah, and that's essentially true. That the fact that a person challenges speed cameras does not mean that one is in favor of speeding. The two are not the same. The question is, if you have a speeding ATE ordinance, what method is there to challenge what may be errant decisions made by the state? And beneath that question is, who has the lawful authority to decide where to put these? Our interpretation of what the DOT did and with the city was that the evidence gathered to prosecute all of these people were solely with the use of technologies that DOT said were unlawfully placed. That doesn't necessarily give a private right of action, but the question is, by what means can a...
Can I ask you a question about that, Mr. Larew? So Ms. Leaf got her citation in February of 2015, which was
Correct.
before DOT said to shut down these cameras. But some of your other clients got citations afterward. Now, when DOT issued the final ruling in May, did the city do anything to try to stay that ruling? I know it petitioned for judicial review, but was there any effort to stay the effect of that order?
No, none that I know of. What was discussed in public domain was that the city suggested that the fact that the DOT had not ordered the removal, therefore they were allowed to continue. And the DOT would say in public ways, we're not giving any permission. They do so at their own risk. When that did become an issue was in April of this year, when the Iowa District Court for Polk County not only found in favor of the DOT and said that the March 17th order and as initially given, and then the May 11th order of that year had been lawfully issued, and the cities asked whether they could continue. The district court said no, you're to turn them off, and I think that issue was appealed to this court, and this court affirmed in an interlocutory order that they were to remain off. So I think the cities have been doing this at their own risk, and because we're not necessarily arguing for a private right of action derived from a DOT order, but rather we think that the DOT order, because these are static conditions that the DOT was measuring, make them unlawful even if raised by a citizen. That is to say, the positioning of the cameras for two of these locations, including the one that Ms. Leaf was...
What is the constitutional dimension of that argument? I mean, how does that violate either the Iowa's federal constitution?
To have an ordinance that doesn't allow a person to invoke statutorily guaranteed rights of defense on the prosecution of a municipal ordinance, we think that is a due process argument clearly. This is the issue here. We start with a statutory argument, statutory preemption. That is to say, the state of Iowa, the legislature, has clearly said, with all the home rule authority that you may have.
Yeah, but Seymour took care of that one.
No, I thought Seymour said, my interpretation, the court of course would know better what it said than I do, but my interpretation of Seymour was a concern expressed as to whether or not motor vehicle owners had sufficiently respected due process rights, and the finding was that the city of Davenport under that ordinance was respecting the minimum due process as guaranteed under the municipal infraction statute of the state of Iowa. The city of Cedar Rapids has ignored that on simple, fundamental things, by the initial process that is served to initiate such a proceeding, by the burden of proof that it uses in its proceedings.
Well, kind of. I mean, I get that argument there, but let's go through one by one. I think you've got three. The first is, well, the Iowa statute indicates that municipal fractions shall be determined in court proceedings, and we can read the statute and we all see the word shall is used. But as I understand this ordinance, the ordinance at least, I understand there's a problem with the notice, but the ordinance at least says, well, there's an optional administrative hearing, but anybody who wishes to end up in the district court proceeding can certainly do so. So what the city has arguably done here is put an informal mechanism to weed out some of the complaints, but yet the citizens' right, if you will, statutory right to have its case decided in court is fully protected.
Well, it's not for this reason, Your Honor, in our view. One is that we know what the state statute requires. Two, the ordinance of the City of Cedar Rapids, specifically at section 1.12, states that any violation of any ordinance, which includes the ATE ordinance, is a municipal infraction, and it specifically cites chapter 364.22 of the code. So when the person gets a notice of violation, it specifically says you have violated the ordinance, and it directs people that if they want to contest it, it doesn't say you may go one place or another. It says you must have an administrative hearing. And then the hearing is held. If a hearing is held and the completion of it, they said you may appeal this now to the Iowa District Court if you wish, or if you get a second notice following a hearing, they say at the tag end of the second page of that notice, you may want to appeal this to the Iowa District Court.
Can you bypass the administrative hearing under the ordinance?
I don't think any reasonable person reading the notice would even know that right existed.
I'm not talking about the notice. I understand.
Yes.
That's another issue, by the way.
Okay.
I mean, the notice, it seems to me, talks about the administrative hearing, says nothing about the possibility of a court proceeding.
Exactly.
And that's arguably problematic.
Exactly.
Although your client got the court proceeding.
She did?
And ordinarily, it seems to me, if you ultimately get your due process rights, that's kind of the end of it, even if the notice was improper. I mean, if there's a personal service made that is improper, but you show up in court, the due process is
there's an
waived.
interesting case. The U.S. Supreme Court said, I think, differently, and that was the Wade decision that we quote. And it states that once you've damaged someone's due process right, you can't repair it simply by having another later proceeding that does follow the law. What the ordinance does say, and I think the interpretation that Your Honor is suggesting, you have to insert a word into the city code of ordinances which is not there. And this has the clause that describes the administrative proceeding, and the other is the district court proceeding. You take those two different paragraphs, and if you insert the word or, it works. There is no word or there, which means any reasonable. Let's assume you have a lawyer who happened to speed, if that's even possible to imagine, and he reads carefully. And he or she reads carefully the text of the ordinance. I think it would be an amazing feat if that person with legal background and knowledge understood that there was an implied or, that they could go directly to the court. What that provision says is those people who are dissatisfied with the administrative hearing, Iowa District Court.
Counsel, was a class certified in this case?
We didn't even get that far.
Right. What happens to the people that just paid their tickets by mail? Do they have any remedy, or are they done?
Well, we would hope in the class that we would want to have certified that they would have a remedy of the remedies we're seeking. One, a refund of payments made. Two, if they haven't made a payments, injunctive relief that the city won't go after them in terms of collections. Those are the remedies that we seek.
What about the city's voluntary payment defense? I mean, ordinarily, if you don't exercise a right to appeal and there's some later developments, your case is over. Aren't all those people done as a matter of res judicata? Who paid their tickets without an appeal?
I don't think Iowa recognizes that doctrine. I don't think it's too late for people to revive an act, and particularly if it's learned that their rights have not been fully respected by the jurisdiction that implemented the ordinance. That would be our argument. In addition to the constitutional or the statutory arguments, we have offered a series of constitutionally based arguments that I can tell we won't have time to cover, but I'll mention them in passing. One is procedural due process, and that is, what is the appropriate process? We think the statute defines it, one, if not the balancing factors of Matthews that would favor a more precise kind of administrative proceeding that respected the rights of those who are in front of the body. Second, a substantive due process argument, under which we are asking the court to consider the adoption of the recognition of a fundamental right of intrastate travel under the Privileges and Immunities Clause of the Iowa Constitution. Third, equal protection is a claim that our clients make, finding that there's no reasonable relationship to the goal of safety, which is our presumption, the only reason that this ordinance exists. There's no reasonable connection or closely fitting tie between that goal and the fact that a technology has been chosen which causes no trucks, no semi-trucks to go through this passage of highway, and thousands of government-owned vehicles, none of them have license plates that show up on the database as a matter of choice. Whereas if they took front pictures of all those vehicles, everyone would be a part of the database. We feel that's a violation of equal protection. And finally, the unlawful delegation argument, one that we don't think has been addressed by this court in any context of ATE cases prior to, and that is whether or not, in two ways, the city can delegate this authority, one of which is judicial, can, in a proceeding established for the purpose of prosecuting a municipal infraction, which is what this is by definition of the code, can this be done by the police department appointing a friend of theirs to serve as a hearing officer, who then issues very officious-looking documents, judgment, decree, order based on all the motions and arguments made, that kind of recital, and then followed by, based on the preponderance of the evidence, which of course is not what the municipal infraction statute requires. Clear, convincing, and satisfactory evidence is the standard for all municipal infractions. Every one of these that go through the hearing process in the city of Cedar Rapids is heard in the least reliable forum, that is just very informal, ad hoc meeting, using the wrong standard of evidence, that is not reducing the likelihood of error, but increasing it. These are serious problems.
All right, Mr. Larew, you may sum up, and you can come back on rebuttal, of course.
All right. And is this the 3 minutes that is for my last remark? Is that what that means?
The red light is on.
Oh, I missed that. Sorry. I'll reserve the remainder of my topic and my discussion for my closing argument. Thank you.
Thank you as well, Mr. Larew. Ms. Kropf.
Thank you. May it please the court, counsel. Mr. Larew and Ms. Leaf through Mr. Larew, as part of the basis for judicial review, has 4 key points. The first of them, as I understand it, being that Ms. Leaf's procedural due process rights were violated in some respect because she was forced to go through an administrative hearing. The first thing to keep in mind with that, and the first problem with that argument, is that she was not forced to go through an administrative hearing. The Court of Appeals correctly found in this case that the administrative hearing process is optional. It's not required.
Well, on that subject, you said in your brief something like, these sort of processes are common where a violation of an ordinance is treated administratively, either as an alternative to or in addition to being treated as a municipal infraction and prosecuted in court. Can you give me some specific concrete examples? Because I'm not a city attorney. I don't really understand. You didn't have any specifics in the brief, so can you
Sure.
give me some examples here?
I'll do my best, and I haven't been doing this for too long, so I'll do my best to give you the examples I've seen. So, for example, if you'd like to get a variance to a zoning requirement, I think most city codes require that you apply to go through the Board of Adjustment to get that as a review. If you are a civil service employee and you're terminated, you're required to go through the Civil Service Commission.
Aren't all those by Iowa statute?
I know the Civil Service Commission is, Your Honor.
I think the Board of Adjustment is too
okay.
in the code.
And I guess I can give you an example of something that's similar, that's not in the code, but that I've seen in practice. For example, when you get to small claims, even as a municipal infraction, Lynn County anyway, and I believe Johnson County, requires you to go through mediation, which is not exactly the same as an administrative hearing, but it's a step that you're required to go through, spend some time, see if you can informally work it out.
That's court-imposed mediation. That's not statutory
Sure.
imposed mediation, and it's a procedure by the court, which is authorized by rules, in order to get to cases. I mean, is there anything similar to this anywhere else that you're aware of that's not either court or statutory imposed?
Well, I'm not certain that the mediation is statutory imposed. I couldn't find it.
No,
but
it's
I'll-
probably court imposed.
It may be a court rule, couldn't find it.
Well, but the problem with this, though, and I appreciate the analogy, if you had a mediation program for these tickets, that was clearly voluntary and the motorist knew if, hey, you know, fine, we can have a court proceeding, or if you want to talk about it, we'll come in and talk about it. I mean, that would be perfectly fine. But, it seems to me, but your notice, for example, talks about an administrative hearing, doesn't mention any court proceeding at all. Frankly, I don't really care for that notice very much. It has, you know, kind of threats about debt collectors and everything else in it. So the notice that people are giving doesn't say, well, you know, come on in for your friendly little administrative hearing. Mediation that's voluntary can always go to court and so forth, and instead kind of threatens civil action for enforcement of judgments or some such thing. I mean, you know, you're recharacterizing what you have here a little bit.
Well, I would like to address the notice a little bit, because I know the Court of Appeals had some concerns with it, and I anticipated that you all would as well. You know, hindsight's 20/20. We drafted that notice when the program first came out. I do think if you read all the way through it, the notice does reference the code section, which makes clear that you have both remedies.
Yeah, the code
and-
section makes clear, but
Sure. And I think, you know, I don't know why the notice was drafted the way it was. To me, knowing the program, I think it makes sense to encourage people to try to go through the administrative hearing. It's a free program. They can go in when most people aren't working in the evening hours and just talk to a lay person. It's less intimidating than small claims court. Gives them a chance to throw out any excuse they want without going through the formal process. But in any event, for whatever reason, I don't think it says they're required to go through the administrative hearing. And just for the court's information, we have actually revised the notice to make it a little more clear for people, because we're not trying to just mislead people.
Can I shift gears here?
Sure.
On the equal protection argument.
Okay.
We know that there's 3 different types of vehicles going through there. There's semi-trucks who aren't even in the database. There's government cars who aren't in the database. So the only one who's getting a ticket are the people who are ordinary citizens, if we believe the arguments made as true. I read the Court of Appeals decision, and they relied on the federal case, which applied federal equal protection, which is, it just has to be plausible to treat these people different. But RACI has a whole other dimension to it, where it has to be reasonably conceivable. How does RACI, and the Court of Appeals didn't apply RACI to the equal protection analysis. How does this scheme, where you don't ticket semi-trucks and or government vehicles, comply with RACI?
Okay. I'm happy to address that, Your Honor. I think the first thing to keep in mind is this isn't a scheme that was laid out to specifically exclude those types of vehicles. It's just they don't return a hit in inlets.
But it doesn't matter whether you did it purposely or not.
Sure.
People have to be treated, similar situated people have to be treated similarly, unless you can get a reason. Now, the federal court says it has to be reasonably plausible. And maybe this is reasonably plausible, and that's what the Court of Appeals did, and that's what the Eighth Circuit did. But RACI requires more. It must not only ask whether the ordinance serves a legitimate government purpose, but also whether the claimed state interest is realistically conceivable, whether the claimed state interest has reason in fact, and lastly, whether or not the relationship or the classification is so weak that it's arbitrary. And one of the tests that it doesn't comply with RACI is that it's either so under-inclusive or over-inclusive, and this seems to be very under-inclusive. So applying RACI rather than the federal equal protection law, how does this pass Iowa equal protection?
I think even under RACI, you know, it's still a rational basis test. It's just one with a little more bite, as I understand it. And I think, you know, the city's got at least two very important interests here. And it's, you know, not only protecting the public, but protecting our officers and our first responders. If you look at the map up here, the exhibit up here, you can see the wind in the road. If you're familiar with the road at all, it also has fairly minimal shoulders. So it's rather dangerous to pull people over on that stretch. We've had officers get hit up there before. So we've got that interest, which is the interest that Mr. Larew tends to focus on. But we've also gotten an interest in enforcing laws within our city limits in a cost-effective manner.
Counsel, I don't think the focus of Justice Wiggins' question is about the city's interest and safety and all the rest. It's about the arbitrariness of the under-inclusion. Could you focus on that in your answer, please?
Sure, I'll give it a shot. You know, I don't think that, the other alternative that I can think of is looking at the front license plate. And I think looking at the front license plate is actually going to be more under-inclusive. There are states, as I understand it, that don't even have front license plates. So that's going to chuck all of those out of the till.
But what is the interest in excluding trucks and government vehicles from the enforcement mechanism?
Well, the interest is they're just not in the database that we use, that we need to use in order to do this in a cost-effective manner.
What does the record show on cost effectiveness? I mean, Justice Wiggins went through the litany of RACI, and one of the phrases used in the RACI test, if you will, is that the asserted legitimate government interest has to be based in fact. Mm-hmm. And so I'm curious what the record shows as to your argument regarding cost effectiveness.
Sure. And, the record in my case was a small claims trial, so unfortunately they're a lot quicker than district courts, and you'll actually see in the record that the magistrate reminded us we needed to keep it moving. So there are probably things in the record that are not in the record I would have liked in there.
Stuck with the record that was developed.
And what I'll tell you is I don't think it's in the record, this semi-truck business at all in my case. So if we're sticking really strictly to the record, I don't think that's in there either.
Well, would there be any legislative or administrative facts that would illuminate on how much would cost to include trucks and government vehicles?
Not that I'm aware of, Your Honor, to be honest with you, just off the cuff that I can think of. But I still think it's, Judge Reed recognized it in Hughes. There may have been a record in that case, though. I'm honestly not certain. So, I'm running real low on time here, so instead of, unless you guys want me to keep talking, I just want to wrap it up a little bit.
You may sum up.
Okay, thank you. The other arguments, the one thing I do want to point out with, he's got preemption and unlawful delegation. With the preemption argument, as I look at 364.22, the municipal infraction section, I think you have to keep in mind that it says, before you get to the shall language that Mr. Larew is directing you to, it says that a city officer may issue a civil citation, meaning that you may issue a citation and drag them into court and get a judgment against them. It does not, as I read it, say you can't have some informal procedure before you drag them into court. And it's certainly not uncommon with at least our city, if we see that somebody's in violation, we send them out a notice, we give them an opportunity to correct it or pay it before we drag them into court and subject them to potential court costs, those sorts of things. So I think you have to read the two together, and I think the burden of proof and the service provisions, all of those apply certainly once you file the municipal infraction in court. But that's different than there just being a violation that you try to deal with informally at the outset. And the unlawful delegation, I'll let my other attorneys here address and not take up your time. Thank you, Your Honors.
Ms. Kropf, thank you as well. Mr. Jacobi.
Good morning. May it please the court. Counsel. In the interests of time, the city of Cedar Rapids in this particular case of Behm will focus its arguments on the issues that have been set out in plaintiff's application for further review, understanding, of course, that the court may wish to ask questions that go beyond that application for further review. So I would like to address the issue of preemption, whether there is a fundamental right or another reason, a fundamental right that requires the imposition of heightened scrutiny in this case, or some other basis for claiming a violation of substantive due process. The issue of whether...
I know you want to talk about that, but I really want to talk about equal protection. And there's no question that this is terribly under-inclusive because trucks and government vehicles aren't in there. There's 3 elements under our Racy decision that will stand mustered under the Iowa Constitution, and both the Eighth Circuit or the federal case and the Court of Appeals use the federal equal protection argument, and sometimes we call our argument rational basis with bite. Some people will even say it's heightened scrutiny. I mean, they call it different things. So tell me how this ordinance, by excluding trucks and government vehicles, passes muster under the Iowa Constitution and meets the 3 requirements of Racy.
So, first of all, the ordinance itself does not exclude anything. The language of the ordinance, that is. In practice or in application, the only method of identifying the owner of a vehicle which is detected traveling at an excessive rate of speed is this database.
But if the ordinance is applied in violation of equal protection, there's still an equal protection argument there.
Well,
It could be neutral on its face, but as applied, if it's going to violate equal protection, it violates equal protection. So tell me how it passes muster under Racy.
well, it actually is not as under-inclusive as one might believe. The truth is, and I believe it's in the record, there have been citations issued to government vehicles. There are certain government vehicles, I think everyone knows perhaps, certain government vehicles which are not in the NLITS database, but some are. And with respect to trucks, some are, I'm sorry.
Now, let me ask you this. A cynic might look at this and say, well, the trucking industry is a powerful force in Cedar Rapids, and government insiders are powerful forces in Cedar Rapids, and they've ended up crafting an ordinance that hits citizens but does not gore the ox of powerful private and public interest. How do you respond to that argument, and what evidence is there in the record to defeat that theory?
Well, that would be a policy decision that the local government would attend to.
We don't want to give the trucking industry a special privilege, obviously.
There is no evidence that the trucking industry has a special privilege.
Is there any evidence that the trucking industry, the trucks that have license plates on the front get ticketed? I take it they don't.
They do not, and there are competing
So
interests.
we need to have, and I guess my point is, okay, fine, and then you have to articulate a reason, and it has to be reasonably conceivable and a legitimate government goes through the racing test. So carry me through the racing test at that racing
Yes,
test.
so the reasonably conceivable interest here is to advance multiple government interests. And those are to enforce the speed limit in a cost-effective manner within the city limits, and to do so in an objective, non-invasive way. Front plates were ruled out for multiple reasons, one of which is that they might be more invasive.
I mean, is it fair to say, as I read Racy, it says that the fit has to be extremely under-inclusive, or extremely over-inclusive. Am I reading the city's position that it may be under-inclusive? So semis and some government vehicles aren't nabbed by this system, but it's not extremely under-inclusive. Is that?
That is
your
precisely the
position?
city's position.
Now, is there anything in the record or any legislative facts that we can take notice of that might indicate what percentage of the vehicles that travel on 380 through the S-curve are in those categories?
I'm unable to bring to mind a specific record site, but in testimony offered, of which there is a transcript in the record by a Rich Cosina, KOSINA, he attests to various statistics about the under-inclusive or about those which do not appear in NLETs.
Let me ask you another question. I'll look at that testimony. Let me ask you another question related to this. What about people with temporary tags, the paper tags? Do those get picked up by the photo radar?
They do not. And I would like to pause and...
It wouldn't get picked up even if you had a front camera, right?
True. That's true. I would like to point out that the vast majority of people traversing this S-curve do not exceed the speed limit at a rate of 12 miles per hour over the limit. So we're already starting with a very small pool, if you will, of those who are subject to receiving a citation.
What were the other reasons front plate system was not used, and how is that more intrusive to do a front plate photograph?
Based on what the police department undertook in the beginning of this, and if I could pause and preface my answer with one point, which is that under the Horsfield Materials case, we do take the position that there needn't be a mathematical nicety, that we don't have to, that the burden is not on the city to come forward with specific comprehensive data to support. But in the interest of answering your question, the reasons that had been articulated in other jurisdictions about front license plates being more likely to be challenged as intrusive because it captures a photograph of the driver's face, the city was not interested in invading or risking that sort of invasion, and instead only wanted to pursue the owner rather than the driver.
My recollection is that the Phoenix system had a front camera, and actually they made sure that the picture of the driver matched with the license plate, and the ticket was issued to the driver. So it's not that it can't be done. It may be more expensive.
And that is another reason, yes. The cost to the taxpayers would be another reason. I don't know.
The arguments on same-sex marriage is that the cost of the taxpayers would be more because all these people would be getting these benefits.
I'd like to distinguish that analysis from this analysis because in this particular case, no one is subject to any sort of governmental interaction or intrusion if they are observing the law. Whereas in the Varnum case, the law itself made it impossible for individuals to pursue what is, arguably always has been, a constitutional right. So with respect to the substantive due process argument, the fundamental right here is clearly not a right to travel. I mean, there is a fundamental right to travel, but it has not been infringed. And again, that goes to the point that no individuals are even brought into this program unless there is an excessive speed. And that also goes to the more tailored mode in which this program has been implemented. That's not in the ordinance either, but there is a 12 mile per hour threshold such that it is narrowly tailored to a more dangerous vehicle. And I'd lastly like to add, in terms of equal protection, that the ATE ordinance does not presume to take the place of traditional patrol. It is still there. It is one means by which the city can achieve those other legitimate government interests in addition to traditional patrol.
Can you give me a number about, or a percentage about how many people actually utilize the administrative hearing process of all the tickets that are, I mean, are we talking 5%, 10%, 1%? What are we talking about here?
I don't believe it's in the record, but what I have understood is that it's around 10 to 15% at any given time. And again, I hate to quote that because it's not in the record, but there are a number of people, by the way, who go straight to the municipal infraction. I can say that.
I'm sorry, do you have any statistics about once they've gone through the administrative hearing, does that resolve it? What percentage of those then proceed to the municipal infraction process?
There is a mix of statistics in terms of depending upon the outcome of the administrative proceeding, the city never appeals a dismissal. So and that's one of the benefits that the city always intended by having this administrative additional process, was that an individual can go in and challenge the elements of the offense, but also in lay terms to another citizen explain extenuating circumstances. City never appeals those or never challenges those findings. So I see that I've gone over and I've taken up time, all of the time that I had hoped to reserve for counsel for Gatso. But with that, I thank you for your time and your questions.
Mr. Jacobi, thank you as well. Mr. Burns, you may have 5 minutes to make your argument.
May it please the court and counsel. I probably won't need 5 minutes. I want to make myself available to answer any questions about Gatso's role in this case. And specifically, I wanted to comment on the claim, I think that goes most to Gatso's conduct in the case, and that's the unlawful delegation claim. I think the district court properly granted summary judgment on the unlawful delegation claim. The test essentially comes down to whether or not the powers delegated are ministerial or administrative, or if they involve significant amounts of discretion or judgment. I think the court correctly found that they did not in this case. And there really,
have any of the courts in the country, you're national, I take it. Every time I travel in other states, I see your name in the newspaper. But has other states found otherwise in the delegation claim, other courts?
So we've looked at a lot of ATE cases in preparing for this. I found one case in Florida. There's a Florida Court of Appeals case. It's the Aram case that found in an ATE system unlawful delegation. After that case, I think it was a 2015 case that Mr. Larew cites, there were 2 cases after that case, 2 other appellate divisions in Florida that disagreed with the Aram case. One of them was the Jimenez case and the Oldsmar case. And one just disagreed with the analysis, and 2, they made a distinction, and the distinction I think applies in Cedar Rapids. The distinction they made in Florida was, in the Aram case, the vendor screened out events for whatever reason that the police never got a chance to review. So the police reviewed events that had been pre-screened and either approved or didn't approve, but there was some other subset of events that they never saw in the first place. In the Oldsmar and the Jimenez case, that wasn't the case. In the Gatso case in Cedar Rapids, it's like Oldsmar and Jimenez. So what Gatso does is when somebody speeds through at 12 miles per hour over, takes a picture, it triggers an event, they call it, and a Gatso employee looks at the screen, sees if they can read the license plate, that's step 1. If so, they enter it into the database, in the NLETS database, see if they can find out who the owner is. If they can't read the plate, it gets screened out in one sense. There's a code that gets put into a database, says couldn't read the plate, don't know even how to run the search. But if they can, they run it through NLETS, who's the owner, and if they find out who the owner is, they code the owner. And that's basically what they do. If they run the search in NLETS and there's no hit, then they code that as well. Everything that they do is reviewable by Cedar Rapids. There is never a discarded event. If they couldn't find the plate, or if a Gatso employee didn't feel like they could see the plate, everything gets reviewed. Everything could be reviewed by Cedar Rapids. They can log in from their computer, and they do, and they can review any event. If Gatso notices an ambulance with the lights on is another example of something they can code. The Cedar Rapids police officer can review that for him or herself if they want to and confirm that it's an ambulance with the lights on. So there's no discarded events, and the critical factor that the district court and other courts have looked at this is there is never a citation issued that does not get reviewed and approved by a police officer.
So all the raw data sent to Cedar Rapids, the ones that are available to them, I guess you don't send it, but undetectable, detectable, et cetera, trucks too, and things that aren't in the database?
Yes.
Sent?
Yes, every camera snapshot goes into the database, it can be viewed. And if it's a semis don't have rear license plates, the police can I guess if they wanted to, they could go out and hire, investigate the semi and try to find out who the owner is in an old-fashioned way. There's no plate, so they don't know who the owner is, but it's still reviewable. They literally log in from a database and, as far as evidence for hearings, they can print off their own exhibits.
Does the trailer have a separate plate than the truck? Is that the problem?
Yep, yeah. Well, I think the problem with semis is there's only front plates. Most states, you're not required to have a rear plate, and they don't have rear plates, so there's just nothing to see. Yeah.
How many of the Gatso systems in other states use the front plate instead of the rear?
I don't know the answer to that. I do know it's possible. I think there was some discussion on this. One reason they don't do it is a cost reason. A second reason is I think there's some hesitation for privacy reasons. The public doesn't like having a front photograph because it reveals who was driving and who was in the car with them and what time they were traveling. And I think it's the photograph of who was riding in the car. There's a privacy concern.
Not sure I
But
understand.
the excess cost as a result of the front plate detection arises, as I understand it, if there's an effort to link the infraction with the driver rather than the owner. Am I right?
I don't think there's any, I don't know, there's nothing in the record in this case that talks about the cost of front cameras versus rear, so I don't want to speak without having any factual basis for it. The other concerns in the delegation argument were that Gatso calibrates the cameras. The record shows that Gatso does an annual review of it, but so does the Cedar Rapids Police Department on a monthly basis, and the district court made that finding. And then just a generic sort of the mailings for the city and the FAQ and the website that Gatso maintains amounted to a delegation, and this district court and other courts have just decided that those are ministerial administrative functions and they don't amount to an unlawful delegation. Thank you.
Mr. Burns, thank you as well. Mr. Larew, make your rebuttal argument.
Thank you. A few points and then a longer thematic statement is where I think I'm headed, but subject to your pleasure. One is I think the right that we are trying to articulate under substantive due process was misstated or mischaracterized. It is, we urge the court to consider an intrastate travel right, a fundamental right under the Iowa Constitution, and believe by doing so in cases like this will allow the elevation of scrutiny that will cause regimes like the one we're talking about today not to have been imposed to begin with, because people will know.
Are you arguing for a fundamental right to speed more than 12 miles over the speed limit?
No, we're arguing that analogous to what the court articulated in Jacobi, where there was a right not to be subject to a rational imposition of fines, we think the motoring public has the right not to be subject to irrational imposition of ATE ordinances.
What interest does Iowa have in creating a fundamental right to travel interstate rather than intrastate?
Intrastate is what I said. Yeah, intrastate. There's a federally protected right of interstate travel, which I think we also recognize, but this would be under the Iowa Constitution, intrastate, and it would be in character with the tradition of our state and the upper Midwest, and I think it would help to elevate the scrutiny given to regimes such as this one. A second bullet point would be this, that beware of the Hughes decision. It's had a nasty effect, a cascading effect that I think has damaged the rights of motorists, but inadvertently. It was a case that we first filed. It was immediately removed. There was no discovery. The court had it without a hearing. There's no record there. And then we appealed to the Eighth Circuit, but the basic part of the appeal, as we understand it, is it made certain rulings as to federal law, but said as to all state law issues, they were deferred or not ripe or all the rest. Well, that holding then has been incorporated, and we think misunderstood or misrepresented or misargued ever since, effectively by those who we are advocating against. But it is a ruling with very limited effect on the issues that we've raised here as a matter of state law.
Mr. Larew, let me ask you a question related to who has the burden on what I'll characterize kind of broadly as the cost issue, and maybe you want to narrow it. But there's some discussion here as to whether, maybe we could have brought in front cameras and so forth, but it has a cost dimension to it, and we're trying to, kind of husband our resources for enforcement. At least that assertion has been made. And the record, and we'll study it closely, of course, the record is sparse on that issue. Who has the burden of showing that an asserted conceivable interest asserted by the government under RACI is not, in fact, what's going on?
Say that again, Your Honor.
Who has a burden? I mean, assuming under our RACI test, there's you could 3 steps, 4 steps, whatever, a valid government interest has been identified, assuming we think that efficient use of government resources is a valid government interest. But then RACI goes on to say that, well, there has to be a basis in fact for the asserted government interest, and then there's some discussion about arbitrariness, over-inclusiveness, and under-inclusiveness. Who has the burden of showing that, in fact, the asserted cost dimension is not operating here?
One, the facts of cost are not in the record, but the contract between Gatso and the city is in the record, and that record says that Gatso is to bear the cost of administration. I don't see how this is, and it's a contingency fee contract. This is concerning to us in a law enforcement matter, that you have a for-profit corporation with a contingency fee contract doing the services that we think are non-delegable for that fee, and it's based on the amount of money collected. But these kinds of costs are ones to be absorbed by Gatso, and it's not in the ordinance. And I think a reasonable interpretation of this kind of regime might well be intended to save Gatso some money. Where's the public interest in this? If this court were to decide that it's under-inclusive, the way that
I'm interested in that. I'm very interested in that. But I do want to focus, and I'll be more sharp. Don't you have the burden of showing that the asserted government interest is not, in fact, operating?
Yes, I think ultimately we do. I think we do.
We have said since RACI 2 that, and even in RACI 2, we said that it doesn't have to be actual evidence. It can be legislative facts. It can be logic, as long as it's realistically conceivable. We're not going to accept something that could not possibly have been something that the legislature really relied on.
And here's the troubling thing about it, and I think it's not by my words, but by the city's words. On some of the most poignant questions asked of them today, the answer is, well, that matter wasn't legislated. That was just decided later. And that's, I think, what happened here. The legislation was the ordinance itself, which says nothing about front plate, back plate. It could have. They could have spoken. It says nothing about costs. It was something that was designed by city staff, apparently, probably under the guidance of Gatso. They're the specialists here. So I think that's a troubling fact. Well, the concluding theme that I did want to come back to, because I do think that it's something to consider, is whether or not, and particularly in the equal protection and maybe more so in substantive due process, for the carefully to consider, and we briefed it for the court, as to whether or not we believe that it would assist citizens to have clearly elevated means of scrutiny. If the court were to scrutinize these kinds of issues with heightened scrutiny, it would happen down in the trenches where people would know they were going to be challenged in that way. I think this ordinance, getting this far down the way with this many problems, meant that at the ground level, there's a real incentive here for out-of-state corporations with a turnkey operation and a promise of cash flow to cities who look at themselves as being cash-strapped for big ideas that they want to accomplish. I get that. Cause there to be a skimming when it comes to the full protection of citizen rights, because that is expensive. That's what the whole idea of a right is. If we didn't have them, we'd have less expense, but we would have a less reasonable place, an enjoyable place to govern ourselves as free citizens in the state of Iowa under our Constitution. Your Honor, I think my time is up, and thank you.
Mr. Larew, thank you as well. The cases of City of Cedar Rapids versus Marla Leaf and Myron Behm and others versus City of Cedar Rapids and Gatso USA Inc. are now submitted to the court.